It's not recording, it is now recording. Welcome everyone to this, another in our series of webinars between King's College London and GW Law School. We're very, very happy that you could join us this morning. This webinar is on post-Brexit UK procurement, the pending waiver reform. We'll be focusing today on the green paper that was published by the UK government that dealt with prospective reform in the UK's procurement laws. We will also be talking about some ancillary issues, and I'll get to those in just a minute. I'm going to share my screen here and bring on the slides. We are very happy this morning to have so many participants from around the world. We have over 450 people signed up. We're very, very happy that you could join us. We have folks from over 30 countries. That's a guess on my part based on domain names, but we're privileged to have you all join us. But here's a map of where all the registrants have come from, and we're very, very happy to have you here. Just a few announcements before we start. We have future webinars coming down the pike. We have one on June 2nd on bidder collusion. If bidders collude, how can governments cooperate? The lead at the U.S. Department of Justice on the anti-collusion task force of the U.S. Department of Justice will be joining us for that session, and it'll be an interesting opportunity to exchange lessons learned between the United States, the UK, and the European Union. We have one on June 15th, Bid Challenges, International Perspectives. This will be the first opportunity really internationally for lawyers and academics working on bid challenges to come together in a roundtable to discuss some of the common issues in bid challenges. The U.S. Defense Department is launching a study this summer on bid protests in the U.S. system, and that's going to be a very comprehensive study, assessing, among other things, what's the purpose for bid protests. One of the issues we'll be focusing on June 15th is, are bid challenges, and when I've discussed this with Jane Jenkins before and in other fora, are bid challenges really intended to remediate harm done to the disappointed bidder, or more broadly, are bid challenges a way to address risk for the government? And we'll talk about those two different approaches on June 15th. Both of those sessions will be at the same hour, 9 o'clock Eastern, 1400 hours in the UK, 1500 hours in Central Europe, and the information will be circulated shortly. I just want to make a quick announcement before we go into the heart of the program here. It was announced on Bloomberg this morning that the United States is withdrawing its proposal to revamp its coverage under the WTO's procurement agreement. In the summer of last year, the Trump administration announced that it was going to revise its coverage under the GPA in order to take out essential medicines, in order to nurture onshoring of U.S. production of those essential medicines for, let's say, the next pandemic. That was extremely controversial. Among other things, it wasn't clear why the United States took that approach, because Article 3 of the GPA would allow the United States simply to exercise what, if it believed it was necessary for national security or for public health, to exercise an exception under Article 3 of the GPA. It wasn't clear why the Trump White House did this. It became clear over the last couple of months as the European Commission made it clear that the European Union was going to launch an arbitration challenging this overall action. That this is going to be a very difficult trade situation. It was going to create acrimony within the GPA, and again, without any explanation why Article 3 hadn't been exercised. According to Bloomberg, in a report published this morning, the Biden administration, per a document circulated by the WTO, the Biden administration is withdrawing that proposal, which is certainly from my perspective, very good news for the international community, international procurement community, which is committed to free and open trade. Okay, so today we're going to have introductions by my dear colleague, Michael Bowsher at King's College. He's going to introduce our panelists. We're going to have presentations, and then we're going to have questions and discussions at the end. All opinions offered are the personal opinions of the participants and shouldn't be attributed to their organization. And during the session, instead of using the Q&A function during the session, please feel free to use the chat function. The chat function allows for interaction between the members of the audience and the panelists, and the public chat is actually recorded, and we'll post the public chat on the Public Procurement International page. Also, this webinar is being recorded, and the recording will be posted on the YouTube page for the GW Law Public Procurement Law Program. So if you look for our YouTube page, you'll see this recording within a few hours. My colleague Jessica Tillman will be posting it there. So Michael, I'll hand over to you.
Thank you very much indeed, Chris, and welcome everyone to another edition of the ever deepening cooperation between King's College London and George Washington University in the field of public contracts. We had a few years under our belt before the pandemic struck, but we've certainly been able to use the last few months to find further and better ways of developing our work together. And welcome today to the party to the Blavatnik School of Government at University of Oxford. And thanks particularly to Chris Jenkins for all of his work in maintaining the infrastructure of all of these events during the pandemic. The website he maintains at publicprocurementinternational.com has a huge amount of information about this and past events and future events. So I highly recommend that. That's www.publicprocurementinternational.com. And that includes links to the full CVs of all of the stellar lineup that we have today. So I'm not going to tell you all about all of their achievements, but let me just briefly introduce them before we move on through the lineup. Chris Jenkins is the Lynn David Research Professor in Government Procurement Law at GW and co-director of the Government Procurement Law Programme, and is widely and frequently published and referred to and cited. He's also of counsel at Arnold and Porter. Christopher Vajda, who will be speaking next, will be drawing out some of the comparison between the UK and EU systems. He was judge at the Court of Justice of the European Union in Luxembourg from 2012 to 2020, and has now returned to practice. During his time in Luxembourg, he was obviously involved in the full range of topics that the Court of Justice deals with, but the way the lottery of these things works, he ended up sitting in a large number of the key decisions in procurement law over that period and wrote some excellent papers in English and French on the important driving role of the court in pushing forward public procurement law. I'm a barrister practicing in London, Dublin and Belfast, as well as visiting professor at King's teaching public procurement on the LLM and directing the distance learning diploma and master's courses. And I've encouraged some of our speakers to add something to their life story today, so it's not all just the usual stellar stuff. So to lead off, for example, as many of my students will already know, and you'll soon see, I can think of nothing more I'd like to do than spend the day working in the panda sanctuary in Sichuan, mucking out after the wonderful animals. After me, we have Professor Anne Davies and Ruairi Macdonald from the Blavatnik School of Government. Professor Anne Davies has an enormously distinguished CV. She's written widely in this area. She's Professor of Law and Public Policy in the Faculty of Law at the University of Oxford. She speaks Welsh and is also enjoying the initial benefits of having had her first COVID jab this morning. So we hope that nothing untoward happens while she's with us, or at all. Professor Luke Butler of the University of Nottingham Public Policy Research Group is the author of an immensely useful recent work on transatlantic defence procurement, and he'll be talking on that. He was national ballroom and Latin dance champion before his partner abandoned him to be a backing dancer for Boyzone. Ruairi Macdonald is pursuing his studies for a PhD at the Blavatnik School. I first met him when he was studying at George Washington. He's kept the faith with public contracts and is working on social contracting issues, which he'll be speaking on. His CV says he travels to Belfast often, which is useful to know because no one's got into my office there for well over a year, and someday someone's going to have to go in before I do. So we'll have to keep in touch there. Jane Jenkins is a partner at Freshfields and has been involved in numerous advisory and contentious matters in procurement. She teaches on our distance learning program, as does Kate Gough, also at Freshfields, and they will be talking to us across a wide range of the key topics raised by the public procurement reform program set out in the UK, in particular on bid challenges, debarment and contract administration. And then finally, Professor Albert Sanchez-Graells is Professor in Economic Law and Director of the Centre for Global Law and Innovation at the University of Bristol. He also has published widely in the field of public procurement, a number of recent and important books he's produced. He blogs actively in the field, and his blog is particularly influential. He's also a keen baker who's survived the shortages of yeast and flour at the beginning of the first lockdown without having to dip into his Brexit stockpile. So, without more ado, rattling through the great cast for today, let me turn to Christopher Vajda, who is going to talk to us about some key differences between EU and UK approaches. Christopher.
Thank you very much, Michael, and to Chris for organising this seminar. I recall shortly after the Brexit referendum, walking through a airport lounge at Frankfurt, and there was an advertisement by the British government which said "Global Britain." I have to say I was a little sceptical about that, but I must say this is really a testament. This seminar is a testament to this, because we have people from literally all around the world, and I don't know whether really to say good morning, good afternoon, or good evening to you. Now, with the departure of the UK from the EU, there is an opportunity to look at procurement in the UK afresh, almost with a clean sheet. I say almost because, of course, as many of you will know, the future UK regime will have to comply with the GPA rules of non-discrimination and transparency, which also lie at the heart of the EU system, as well as the UK EU TCA. Now, the Green Paper entitled Transforming Public Procurement calls this a historic opportunity, I'm quoting, to overhaul our outdated procurement regime. The stated objective is, and again I quote, to create a regulatory framework that delivers the best commercial, and I stress the word commercial because I'll come back to that, because I think this is one of the problems in public procurement. Anyway, delivers the best commercial outcomes with the least burden on businesses in the public sector. So there's effectively a strictly, if I can put it this way, commercial approach. And the Green Paper describes the current EU procurement regime as complex and inflexible. And I have to say, as a result of my time as a judge at the court, there is undoubtedly more than a grain of truth in that observation. But in designing a new system that presumably is intended to be less complex and more flexible, one needs to understand the cause of the problem with the old system. Now, part of the problem of what I call the complexity problem stems from more and more detailed rules. The first public procurement directive, which was adopted in 1971, I think ran to all of 10 articles. The EU rules have become more and more complex over the years because the EU legislator has sought to use public procurement as a lever to pursue a host of public interest objectives other than purely economic or commercial. And by that I mean accepting the bid, the lowest price bid, or economically the most advantageous. And we've now got to a situation in the EU where the legislature is seeking to micromanage virtually all elements of procurement. Thus, other public sector, public interest objectives such as the environment, promoting economic and social cohesion have been added on. And this, of course, a bit like Topsy, increases the complexity. And at the same time, in terms of procedures, what can and cannot be done by contracting authorities, the EU legislation has laid down more and more detailed rules to give flesh to the broad principles of non-discrimination and transparency. Now, as to the inflexibility problem, there is undoubtedly a problem here. And it's a problem that I experienced as a judge on many occasions. virtually all the public procurement cases I sat on arose out of an exclusion of a bidder or a tenderer who complained about some aspect of the tendering procedure. And a common complaint was, should one not allow a tenderer who has complied with most of the obligations, but perhaps hasn't complied fully, the right to correct his error? In other words, shouldn't one apply the well-known principle of proportionality? However, the difficulty in that is that flexibility for one tenderer, i.e. let's be a little proportionate, could result in discrimination against another tenderer. And one asks the question, which is a question that we debated quite often in court, why should a tenderer who has not complied with one requirement be given a second chance when his competitor has fully complied? And so the difficulty, in my view, is to strike the right balance between, in this case, non-discrimination and flexibility. Now, having said that, it is indeed possible for the UK to have a simpler and more flexible regime, as the Green Paper proposes. Whether that will occur is another matter. To start with, the Green Paper goes out of its way to stress that the new public procurement rule should seek to achieve a very large number of objectives. The government seeks to legislate for a large number, I think, if my arithmetic is right, 6 principles, which are to be part of the UK's public procurement regulations. Now, and we've got one on the screen here, the public good and value for money. Now, under the principle of the public good, we are told, paragraph 29 of the paper, that public procurement should also be leveraged to support strategic national priorities. And in relation to value for money, it doesn't just mean economic value, because you'll see that it refers to the selection of supplier that offers the best social value for money, social value for money. Now, in my view, while this is all very well intentioned, it is pushing very much in favour of a system that is not simple but complex. And of course, it is also impossible really to see how these, and I don't in any way criticise these very laudable public interest objectives, being consistent with the stated objective, which I mentioned at the outset, of delivering the best possible commercial outcome, because it seems to me quite clear that the best commercial outcome is not what is being sought. And if one, and I think Jane and Sarah will go into this in more detail, but if I'm allowed to look at this at a high level, if one looks at the award criteria, one begins to see the difficulties. I'm just going to mention 3. Now, at the moment, under the EU system, tenders are evaluated on the basis, or can be, on the most economically advantageous tender, meet, as the Green Paper describes it. But the Green Paper says, well, let's move over to a slightly different system, the most advantageous tender. So the word economically is removed, so we move from meet to mad. And this is to enable the contracting authority to take, and I quote, a broader view of what could be included in the evaluation of tenders in assessing value for money, including social value as part of the quality assessment. And this certainly will give the contracting authority greater flexibility, but it is going to be at the expense of certainty and likely to lead to more litigation. And perhaps I could just interject here that public procurement is this slightly odd creature in the sense that nobody really quite knows whether this is it really private law, as we say in English, or is it public law? And it's not public law in the sense that you can simply go along to the court and the court will do what we might call a light touch judicial review. The court will get into the detail, and therefore if somebody says, well, I'm doing this because of the public good and because of this is going to achieve greater social value, while that might be sufficient in a judicial review, that is going to come under very close scrutiny in a public procurement challenge. Now, the second of the three award criteria that I want to mention is that the Green Paper acknowledges it's important to retain the requirement that the award criteria should be linked to the subject matter of the contract, which obviously makes sense. But it nonetheless proposes certain exceptions to this to enable the contracting authority to assess how the supplier is operating across the whole of their business, i.e. not related to the particular procurement. Now, if this is adopted, this will, in my view, create an additional layer of complexity, not just for the bidding undertakings, but also the contracting authority and those who advise contracting authorities, with no doubt an increase in the costs of procurement. And again, this will lead to more uncertainty and legal challenge. And it is an example of how, yes, we can have more flexibility, but it is at the expense of simplicity. And then the final example I want to give is the proposal to remove the requirement that the most economically advantageous offer, or the MAT, be considered solely from the perspective of the contracting authority, thereby enabling the contracting authority to take account, and again I quote, of broader economic and other impacts into account. So this, in a nutshell, what I'm saying is that this is all very, it's like motherhood and apple pie. This is all very laudable to attach a number of public interest objectives, but it's not going to, in my view, create a system that is less complex than the system that we have at the moment. Now, finally, before finishing, a word on challenges to the procurement procedures. I think it's a great tribute to the British judiciary that during the UK's membership of the European Union, they were able to resolve virtually all public procurement cases without a reference to the court. And indeed, I was very surprised at references that came from other countries in relation to litigation that, so far as I could see, was completely stale. Of course, it was of interest to academics and lawyers as to the future development of the law, but really wasn't very much interest in relation to the procurement in hand. Now, the small incremental changes that are proposed in the Green Paper to the judicial process seem to me to be sensible. However, I come back to my main point, which is that the more flexibility that is given to the contracting authority, and the wider the number of objectives that need to be complied with, the more likely it is that they will be court challenges and that they will take longer to resolve. So to conclude, what in my view is important in public procurement is to get the balance right between simplicity and flexibility, while ensuring, of course, the principles of non-discrimination and transparency and fairness are respected. As I said, in my view, the EU rules have become too complex, and for my part, I would welcome a UK approach which was simpler both for suppliers, contracting authority, and, dare I say it, judges. Thank you.
Thank you very much, Christopher. I will pick up the baton. And there's the photographic proof of that I will spend time with pandas. And a shameless blurb for our course. I've got a lot to cover, so let me rattle on without dawdling for too long. Firstly, I think I should firstly pay tribute to the authors of the Green Paper. It's got a lot of useful material in, and you pray also in advance thank them for the burden they've taken on of reading all the responses to the consultations. I know there've been numerous hundreds of responses. I've certainly not. I've seen many of them. I've certainly not managed to read more than 100. There's going to be a lot of work for them to do, and I don't know how they're going to sew it all together. Having said all that, I think there are points to be made and maybe shortcomings that need to be picked up. We start, of course, from the fact that public procurement has been framed for most of my professional life in the UK as something that needs to be deregulated. Public procurement law was an unpleasant piece of medicine which needed to be accepted as part of EU law membership but the rationale seemed to be we didn't have it before. Question whether that's really true, but let's park that for today. And therefore we didn't really need it in the first, it didn't need it at all. It was just one of those annoying nuisances which got in the way. And as one judge once put to me, public procurement law, isn't that the thing that stops public authorities from doing the thing they should be doing? And that was in open court, as I recall. So there is certain, if we can just move on to the next slide then, Chris. The rhetoric, it was no surprise that the Brexit rhetoric was that when we leave Europe, we will be able to fashion our rules and produce the best procurement system in the world. A noble aspiration, and while of course that comes out of the deregulatory bias that has been built into the British sort of political structure, and particularly the Conservative Party, it had a noble goal. However, as has already been noted, what we could really achieve was seriously limited by the inevitability of our signing up to the GPA. And in a sense, it seems to me that we've probably made that problem worse by the way in which we have affected our withdrawal, because rather than retaining a sort of an arm's length distance from the GPA like so many regimes, we've gone the other route and really integrated the GPA into our legal system. We haven't gone quite as far as in Hong Kong, where the GPA is domestic procurement law, but because of the way in which the GPA forms part of the Trade and Cooperation Agreement by incorporation in Title VI, Section 29 of the Future Relationship Act has the effect that domestic law will have to be interpreted in such a way as to give effect to the GPA, because the GPA becomes part of the TCA. That effect was perhaps was not necessarily anticipated, given that there wasn't clear through much of last year how far, if at all, public procurement law was going to feature in the Trade and Cooperation Agreement. Once that came in and this became part of the acquis, we now see that there is something really rather different about the way in which the GPA applies, because the effect under Section 29 is not like the old direct effect of directives, which took place in very specific and well-defined circumstances. It is now a universal pervasive obligation always to interpret domestic law in a manner that gives effect to the TCA and therefore to the GPA. Well, does that matter? You might be said, well, wasn't the whole point that the PCR complies with the GPA and therefore the point doesn't arise? Well, government has already noted that the point does arise in PPN 0221, which I've noted. They've identified at least one place where it arises, and I'm not going to spell it out now. Do look it up. Others seem to me to be even more obvious. For example, the GPA includes no sufficiently serious breach threshold for a damages claim. And the argument which was applied in Energy Solutions, which introduced the Frankovich requirement that a breach be sufficiently serious for it to sound in damages, can only flow from EU law. We've got rid of that, but we've retained the GPA. And if our remedies are to be compliant with the GPA, presumably they're to be interpreted in the light of the GPA. And that reinforces the fact that, of course, Frankovich, in any event, is no longer an independent basis of claim. There are other aspects of the GPA. It seems to me that the law on modifications, cancellations, might, in some fact circumstances, benefit for some looking at, because it doesn't seem to me that necessarily the existing PCR covers the point. And I think when one looks at the principles, Article 4.4, the obligation to prevent corrupt practices, looks really rather interesting in the week in which the FT's big read was under the title, How Sleazy is British Politics? A principle of law which now appears to be enforceable, that procurement must not just prevent conflicts of interest, but actually prevent corrupt practices, has at least the potential to be rather strong. So Section 29 of the Future Relationship Act seems to me to raise some rather important changes. or at least limits on the way in which we can reform. Other factors from Brexit, of course, are also important. I'm not going to take too long to talk about the obvious problems that there are going to be in bringing the Northern Ireland and Scotland and increasingly Wales along with any reform package, given the different pressures that they will be under going forward, both politically and commercially. But I do want to come back to a point which Christopher has already touched on, principles, but do so in a slightly different way. Back in 2004, Professor Sue Arrowsmith talked about the possibility of getting rid of much of the technicalities and focusing on principles such as transparency, equal treatment, proportionality, narrowing of competition, and so forth. But that focus at that time was very much, as procurement law was then, a focus on the internal market and the treatment of bidders, the need for certainty in bids, so as to encourage bidders to feel comfortable when they put in their bids, that they could invest in the bid process. These are very important factors, and they're at the heart of our remedies process. Our remedies process in the UK privileges bidders as the primary way in which procurement law is enforced. And those principles make sense because they in effect create the sort of the procurement law duty of care in statutory terms. And as we got used to it, that's the way in which we understand authorities have to look after bidders. A number of the new principles which are now identified, public good, value for money, integrity, fair treatment, perhaps a broader concept, and perhaps some of the other principles which don't get a look in, such as competition or innovation, may be very important principles or goals of public procurement, but they haven't been spelt out in rules, and they're very different from equal treatment. These are not principles which are going to be enforceable by or not naturally enforceable by bidders. They're going to be enforceable by civil society, by a whole range of additional bodies. And it seems to me that very little, it's all very nice to put these principles in, but whether they're good or bad, very little thought has been given to the technical consequences of legally enshrining them in our regime, because the consequences will be to create a number of open textured principles, which will be enforceable by people other than bidders. Now that may be fine. We're seeing this already in the pandemic procurement litigation, in a number of the cases going forward. This may be the future. But it is then unrealistic to look at the remedies section of the Green Paper as being a sufficient response to the resourcing and other challenges going forward if you haven't thought realistically about, well, who actually is going to be enforcing the public good and how is that going to happen? It seems to me that in a sense, for a number of reasons, perhaps the need for pace, the GPA constraints, there was a lost opportunity to actually pass this whole project over to someone who actually would have been in a position to think about what the best procurement law in the world would have looked like. Someone like a body like the Law Commission, whose job it is to create fresh new law, might have been better placed to actually look at this afresh from the ground up, rather than produce what it seems to me is a Green Paper that is rather focused on hobby horses, but perhaps not direct hobby horses of particular interest groups. And so we have lots of incremental changes in a terribly English way without necessarily dealing with things. I'm just picking up your point, Chris, about Singapore, but Singapore still uses the old UK regulations as its domestic legislation. It hasn't actually incorporated the GPA directly in the way that Hong Kong has. In fact, its regulations are, I think, the 2006 regulations, if not the earlier regulations. So there's this whole problem, I think, going forward about how we deal with these problems. There's much more to be said, particularly about bid evaluation and how this is being dealt with. But I'll be dealing with bid evaluation on a subsequent occasion, so perhaps I can park that for later. As I say, as I've indicated in my pictorial diagram, one of the real problems, it seems to me, is that we've got rid of the rich diet of foie gras, but we're now left with a rather uncertain blend of meats with, well, a very bad joke, only 90% meat. Anyway, there we are. Moving on, enough of me. Now, the next, let me just remind myself as chair.
No,
what I'm
I
supposed
wanted
be
to say,
doing.
Michael, for years, I wondered where Monty Python got the words to my favorite song, and now I know. Thank you,
Now I
Michael.
know. From Minnesota, you didn't know it was an American product, did you? From Austin, Minnesota.
Let me just take us to the next slide.
Right, Professor Anne Davies. Anne, do please take it away. Take your time. We're running behind a bit, but we'll keep it going.
Yeah,
please take it away.
I don't think I can get through in 1 minute.
No.
So thank you very much for the invitation and the opportunity to speak today. Going to be a slight change of gear from me and from the next speaker. So I'm going to be talking about social contracting. Ruairi Macdonald, who's speaking next, and I, between us, run a peer learning group called the Procurement of Government Outcomes Club, POGO for short, which is part of the Government Outcomes Lab at the Blavatnik School of Government in Oxford. And we're interested in ways of using procurement to improve social outcomes. Our group meets monthly online. You're all very welcome. You can just Google us and sign up. And we hear about the latest research and practical developments, and we share knowledge and experience. And our members include policymakers, procurement practitioners, practicing lawyers and academics from many different sectors and countries. So a subset of the POGO Club responded to the Green Paper. You can find the response online together with the list of signatories. And we have a particular take on the Green Paper proposals, given the type of contracting our members are interested in. And I'm going to try and give you a bit of a flavour of that today. So it might help if I start by explaining a bit more about what we mean by procurement of government outcomes, in case that's not a familiar idea. So in simple terms, an outcomes-based approach to public services involves thinking about public services in terms of the goals we're trying to achieve rather than the services we're delivering. So for example, reducing levels of unemployment rather than providing a job placement service. So focusing on the outcome rather than the service being delivered. So in terms of procurement of outcomes, we're thinking mainly about contracts for the provision of public services where, instead of going into a lot of detail about the exact nature of the service to be provided and paying for that, the contracting authority instead says to the contractor, here's the outcome we want you to achieve, and we're going to pay you by results. Each time you achieve the outcome, you're going to get paid. We're also interested in our group in social impact bonds, so where you get a third-party investor involved as well as the public sector purchaser and the service provider. And of course, we're also interested in social value, which has had a bit of a mention already this afternoon, where the contract itself might not be for a particular social outcome, but the public authority uses the opportunity of the contract to get the contractor to deliver some social value alongside the main objective. Now, all that having been said, the kinds of social outcomes contracts that we're interested in aren't easily defined in law. It's not straightforward to just bracket them off somehow into their own separate legal category, but they are quite an important part of the procurement landscape in the UK. So from that very particular point of view, the worry about the Green Paper is that it doesn't really take account of this kind of contracting, or really any kind of contract for a complex public service, in the way that it frames the issues. And that's kind of the big point that I've put on the slide, the sort of commercial transactional against social and relational. So from our point of view, the Green Paper is all about commercial or transactional procurement, competition for fairly standard goods and services on the market as the paradigm. So that's what people were thinking about clearly when they drew up the Green Paper. And in the context of social procurement, our experience is that you need some rather different things. So you need a culture of relational or partnership working that focuses on situating procurement in the context of the authority's wider policy goals, engaging with local actors in a process of market creation and development, not just running a competition, and developing truly collaborative relational contracts in which the public authority and the contractor see themselves as partners pursuing shared goals. And so our concern is that the Green Paper taken as a whole doesn't really consider how to foster these kinds of approaches in those instances where they're relevant and appropriate. And in fact, the Green Paper explicitly excludes from its scope some of the sectors and bodies of law that are specifically concerned with social procurement. So healthcare isn't covered, the Social Value Act isn't included in the discussion, nor is local government legislation. Of course, it's understandable that the drafters didn't want to overcomplicate their task or disrupt settled areas of law. And I'm sure they've got a lot of work on at the moment, and they're glad they didn't take on any more. But it does mean that we're not going to end up with a comprehensive regime covering the full spectrum of different types of procurement. So I think very much echoing what Michael was just saying about this being a bit of a missed opportunity to really reform the whole field. I'm going to move on to a couple of more specific points, which I'll make slightly more briefly, and I won't take them in quite the order that they appear on the slide. I'll just talk about flexible procedures first, if I may. So, as you'll all know, one of the key proposals in the Green Paper is the introduction of more flexible procurement procedures. Our members know quite a lot about this because, of course, they have experience with the light touch regime for social health, education, and other services. And we broadly welcome the greater flexibility. But the key message we have here, and we've emphasized this in our response, is that flexibility in the law doesn't necessarily result in more flexibility in practice. Problems arise not because of the procedures as such, but because officials are afraid of getting things wrong and they're afraid of being sued. And this leads to things like using really well-known procedures instead of potentially more suitable but unfamiliar procedures, and an overly rigid application of the rules. So to address this, we would say, firstly, there needs to be much better guidance and training for procurement officials to foster confidence and creativity rather than just compliance. And careful thought needs to go into the mechanisms for disappointed bidders to challenge problems with procurement exercises. Of course, these need to exist. Many of us would say that mechanisms for citizens to bring challenges also need to exist, but they need to be carefully designed so that they don't contribute to risk aversion. And creating new quick mechanisms for challenge could really cut either way in that regard. Let me say something about oversight and learning. Again, many of you will be well aware that one of the proposals in the Green Paper is to create a new unit to oversee procurement and to improve the commercial capability of public bodies. And again, we think there are considerable gains to be made by designing the procurement regime so that it's constantly learning and improving. That's the best safeguard against poor outcomes, poor value for money. But it's important that the oversight body has the right mix of skills and experience and the right focus. We would say it shouldn't just be about commercial capability, but about all relevant capabilities, including delivery of services and outcomes, and should be framed less in terms of oversight and more in terms of shared accountability and learning for the system as a whole. And then finally, just to go back to the point that's there on the slide about law reform and transformation, one of the responses you might immediately have to what I'm saying is that the Green Paper is about reforming procurement law rather than procurement more generally. Procurement law is only one aspect of success or failure in the context of procurement. But then don't go calling it transforming public procurement. If that's the ambition, you can't do that just through legal reform. You need much more effort into things like guidance, sharing best practice, training procurement officials, and raising the profile of procurement and commissioning in all its forms among senior leaders in public sector organisations. I'm going to stop there and hand on to Ruairi, who's going to develop a couple of other points from our response around opportunities for social outcomes contracts and around transparency and data sharing. Thank you.
Ruairi,
thanks very much, Anne. So my name is Ruairi Macdonald, and I'm a research associate at the Government Outcomes Lab over in the Blavatnik School of Government. Anne and I, as Anne mentioned, host the POGO Club. That's not the means of transportation. That's the Procurement of Government Outcomes Club. And if you're interested in the things we have to say, you're very welcome. We have a session coming up at the end of the month, and we have monthly sessions. And you're very welcome to that and to the Social Outcomes Conference that we have coming up in September. A deadline for the call to papers is happening at the end of this month. Anyway, my name is Ruairi Macdonald. As I said, I'm doing my PhD and completed a master's in public procurement law at the George Washington University. Chris is my supervisor. And like I said, I'm working at the Blavatnik School, where I'm focused on data issues. We have an international network for data on impact and government outcomes, our Indigo initiative, that's relevant here, as well as the POGO Club, which is focused on public procurement. Anyway, to add some comments to everything that Anne has said, I'm going to focus on social outcomes and particular social outcomes framework. And I'm also going to say a little bit about transparency and learning, in particular focusing on chapter 6. I'm going to be fairly brief, but I do want to emphasize something for our US friends. The reason that we're having this conversation about social matters is because, well, one reason is because in the UK and in Europe, the rules are applied all the way down the system or through the system. So local authorities, when they're trying to impact people's lives, are looking at these rules as well. If I was interested in, and I am interested in social outcomes in the US context, I would not only be looking at public procurement, but I'd also be thinking about the work that local governments do. Many local governments in the US, have different procurement systems. They're not all subject to the federal system. There's a whole system around formula grants and so on. But here, if we're talking about the UK, then procurement and procurement impact on social outcomes becomes very, very sort of important, and I hope that's helpful. The other thing that's interesting is, there's been conversation about this, is this sort of commercial versus publicness. David has highlighted earlier in this conversation, the sort of where that tension becomes important with different economic actors. If we're thinking about social outcomes, then we're also not only thinking about the economic actors that are sort of, I want to bid, I want equal opportunity, in this bid, that kind of conversation. We're also thinking about the people who are served, the beneficiaries of these contracts, and what are their rights in this whole thing. So that's something that interests me, and that's something that interests the group, and that sort of informs the following points. We are thinking about whether or not there should be some kind of special procedures around social outcomes, in particular perhaps around social outcome frameworks. When I say frameworks for US friends, I'm talking about like IDIQs, GWACs, and other sort of like umbrella contracts, or as others have said, there's like a two-stage thing. You get on the thing, and then you bid for call-off orders or task orders, and then you start work. So that two-stage contracting, like a social outcomes framework, we think may be important. We don't know yet what the details of the proposed reform are, so it'll be interesting to see what comes out of the white paper. Reasons that we think this is important include, if you're dealing with social outcomes, the outcomes don't happen for a long time, so you may need longer contracts. We also think that getting on and off the first stage is important, particularly if you want voluntary sector organizations, community, social enterprises, VCSE, the sector to be able to participate in such a thing. We also think that this is a timely and an important sort of thing to think about, because there are additional funds being set up when we talk about building back better post-pandemic. An example of the issues that I'm talking about here comes from the UK's Life Chances Fund, which was a fund that set up and allowed social impact bonds to be created. And you had about more than 30 different local authorities trying to procure and set up their own social impact bonds. But did a lot of learning to do, and it was quite challenging for them. It took a long time. And so our thinking is that perhaps setting up these kind of two-stage framework or umbrella type contracts might be more efficient and effective for local authorities. I'm going to move now to talk about transparency and learning, where the idea of local authorities is, their focus on local authorities is going to come through as well. I really like Chapter 6, and many members of our group like many aspects of Chapter 6, which is focused on transparency. One of the focuses includes one of the things in Chapter 6 include a focus on open contracting data standard, and a system to share procurement notices, and some things post-award. Obviously, transparency has been in the news a lot, and there's been a lot of highlight on the importance of transparency. I think lots of people say transparency is really important. I think it's also helpful to go on and think about what are the operations of that. So we all agree that transparency is important, and we're thinking about where the burdens for that transparency lie. If the benefits for transparency are felt by the community at large, and by oversight of, by citizens and others, then the burden, placing the burden on a local authority to sort of manage transparency on an individual transaction maybe is challenging, and so we're thinking about different sort of solutions for that. How can we help local authorities who are rightly focused on transactions and making, doing an efficient transactions, but thinking about, well, how does this work on a system-wide level and who's benefiting? So we've got some solutions in there. The suggestions include things like, providing central government help desks, help support, and maybe embedding students within or others within local authorities, so that there's a capacity development thing happening. Anyway, I'm going to move on. The transparency and learning piece, I think, is important. Michael earlier commented on, challenges around sort of adding things like social value into the public procurement system. We think that a better understanding of what's happening in the public procurement system through things like the open contracting data standard becomes really important there. There are a lot of anecdotes from lots of different places about why social value might be helpful. We were bolting on things let me pause. When I talk about social value, what I'm talking about here is the idea of putting, the creation of jobs and bolting that onto, a contract for, building a road. And so the social value aspect might be, we're also going to hire X number of apprentices, and we're going to give you this amazing road. And some of the challenges there include, well, how do you measure, what's a good sort of social value add, but also then how do you monitor, and this is what we're interested in, how do you monitor that those apprenticeships have been created? Is that the right thing to do in that area once you sort of step back to for the system thing? Obviously the companies that do roads really well. Do they also have really great employment programs? I don't know, but we want more data to understand this. And I think there are other users that also want to understand this. So one of the questions that we have when we think about transparency and data and learning is, well, whose role is it within the system to sort of step back and think, is our procurement system working? What social value is being applied in different places? And is this idea of applying things like social value, an effective thing to do? Anyway, I'm going to pause there, I think, and give up my time. And just remind you that if any of these things are interesting to you, you're very welcome to participate in the POGO Club. And we have the Social Outcomes Conference coming up in September. So thank you.
Great. Thank you very much indeed, Rory. As everyone has got much more to say than we have time for, but this little taster. Moving the sort of sharp change of gear, this is when someone sort of puts the handbrake turn on the car and we head off in the direction of defence. I'm sure there are social outcomes to be achieved as well, but I'll leave it to Luke to see whether he's got time to blend that in as well. Luke, please take it away.
Thanks very much, Michael. I don't think we'll have time to discuss social outcomes in defence procurement. That's a seminar in its own right. But yeah, defence procurement, sharp change of focus. It hasn't been discussed much in debate on post-Brexit reform. In this short presentation, I'm going to outline a possible direction of travel. First, just to offer some context, which I haven't included on the slide. Basically, up until 2009, most EU member states excluded much of their defence procurement from the scope of the EU treaties altogether, pursuant to an essential security interest derogation under Article 346. As a result, many defence contracts weren't opened up to competition EU-wide. So in 2009, the EU decided to adopt a Defence and Security Procurement Directive to subject lots of those defence contracts to EU rules and reduce the practical scope of operation of Article 346. Now, a 2016 Ministry of Defence review that reviewed the UK's implementation of that directive found that we actually did a pretty good job at complying with the Defence Directive. So all was pretty much tickety-boo in the area of defence procurement as far as our compliance was concerned. So where do we go from here post-Brexit then? Well, understandably, given the constraints, the Green Paper says very little about defence procurement, except that there would be an ongoing consultation with the Ministry of Defence. The starting point for us then is not actually the Green Paper, but the UK's new Defence and Security Industrial Strategy, which sets out the plans for the UK's defence procurement policy in future years. The first thing to note is what the strategy says about the UK's international obligations in this area. So for anyone thinking about any kind of buy British defence policy, the reality is that because the UK undertakes so much overseas contracting and we export systems abroad, that it's unlikely that there's going to be too much risk of foreign retaliation. Ultimately, and unsurprisingly, I suppose, the strategy simply says that the UK will comply with its international obligations. What does this mean in real terms in the context of defence procurement? Well, most hard defence procurement, at least, is likely to be excluded from the international legal frameworks. As has been indicated, the UK has acceded to the WTO GPA in its own right. Defence is excluded from the GPA. And further, there is an essential security interest derogation like Article 346 under the GPA. Further, defence isn't covered by the UK-EU Trade Cooperation Agreement, at least expressly. And similarly, if we've got ambitions for any kind of comprehensive and progressive agreement for a trans-Pacific trade partnership accession, there's a national security exception in that too. So unless I'm mistaken, in 2019, Canada, who's also undertaking its defence procurement reforms, proposed to require that the Canadian International Trade Tribunal dismiss complaints where a procuring entity invoked a national security exception, expressly contemplating the kind of CTPP exception. So the upshot is, to be quick, I can't see much hard defence procurement coming within the remit of the international procurement rules. That said, we mustn't forget the important political initiatives that do provide certain legal assurances. So in the UK, for example, these are still in force. There is the US-UK Reciprocal Defence Procurement Memorandum of Understanding, which guarantees equal access and treatment to US suppliers in the UK in their procurements, and similarly, UK suppliers get a waiver of US binational and other domestic source restrictions when bidding in the US. So there's also a political element that we need to consider in terms of assurances that we're offering to foreign partners. So provided we comply with our international obligations then, how do we regulate domestic defence procurement? Well, the new strategy expressly states this: it is no longer the UK's assumption that global competition is always best to meet UK needs, and that this assumption is to be replaced with a much more sophisticated and nuanced approach, whatever that means. Are there any clues then as to what this approach is and what will drive it? Well, at least one driver is likely to be the extent of single source procurement in the context of defence. So the strategy expressly states that 35% or £8 billion of Ministry of Defence procurement money is spent each year. So it might be argued that if so much of our defence procurement is single source with either limited competition or no competition at all, it isn't necessary to gear our system towards international competition. Of course, that doesn't preclude us awarding contracts to overseas contractors. So that might be one driver. This new policy also means being more flexible, streamlining procurement, enabling more innovation, which, although vague, seems to align with the broad objectives of the Green Paper. Now, in this regard, the strategy expressly refers to the Green Paper proposals for a single uniform set of rules. Consolidation of rules in the defence sector is actually probably a sensible thing. So to give you an idea, in 2021, commercial officers that are looking to award a defence contract currently have to read a 2009 Defence Directive that was modelled on an outdated 2004 Public Sector Directive, which was itself replaced in 2014. And in addition, commercial officers have to decide which directive applies for any civil procurement. So having one reference point would be useful. Further, the Green Paper proposes to allow use of an open competitive procedure. Now, despite the utility of that kind of procedure, an open procedure was not available under the Defence Directive. So that's a quick win. Concerning more substantial changes, the Green Paper simply states that it will be supplemented with defence and security specific rules. So this leaves us essentially to speculate at the policy level as to what will be implemented. It could well simply mean clarifying the scope of any national security and other exceptions, so undoing some of the strict limitations that the EU tried to place on those exceptions. It may also mean clarifying certain exclusions to continue to permit international cooperation, for example, with the US under foreign military sales contracts, and leave the door open to cooperation with other EU countries. It could also mean clarifying provisions on sensitive security-related procurement, so not hard defence procurement, but intelligence and security service procurements being a potentially greater concern in terms of the need for flexibility and compliance than hard defence procurement. So that's the general direction of travel under the Green Paper. Now, as indicated, there's also an interesting focus in the Defence and Security Industrial Strategy on single source procurement going forward. Seems to be a particular hot topic for the Ministry of Defence. Now, in 2015, the UK adopted single source contract regulations, which only apply to qualifying defence contracts. And put simply, the objective of those rules is to limit cost overruns and excessive prices that were historically seen on single source defence contracts. How do they operate? Well, the regulations introduce a baseline profit rate plus recovery of allowable costs, much like under the US federal acquisition regulations. This is ultimately to ensure that contractors get a fair return on their contracts, but also subjecting contractors to transparency through increased contract reporting. Now, the regulations don't derive from EU law. They're a purely domestic initiative. So they are a Brexit dividend, as it were, but the strategy indicates that these rules should also be reformed. Now, in view of the time, I don't propose to go through the technical issues that may lead to reform of the single source contract regulations, but in broad terms, the Ministry of Defence are concerned about the proportionality of these rules. Industry don't like the fact that they've only got a baseline profit, so they're eating into profits, and there are general concerns about how information that is provided under these contracts is going to be used. And there's a command paper due to be out later this year that will set out those reforms. So key takeaways are, to be quick, firstly, the UK's international obligations shouldn't prevent flexibility to conduct defence procurement. The defence rules will form part of a unified regime. The Green Paper is going to address certain long-standing criticisms, but it remains unclear what those defence-specific rules are likely to be. And the burden will be on the Ministry of Defence, no doubt, to justify why it should have any special treatment. And then finally, there is an objective to move away from global competition in all instances, and we need to watch this space regarding any increasing focus on single source procurement done domestically. Thanks very much.
Thank you. That's very, very useful. I mean, the single source, obviously, defence is hugely important for public procurement generally. I think the largest recipient of public purchasing funds last year was BAE ships, just to illustrate just how significant they are to the overall budget. But also, I think the single source piece is interesting because what, of course, the pandemic has revealed is that defence may not be the only market in which we have inverted markets with single sellers, or at least where their sellers have greater power than procurement law necessarily presupposes, and there might be some crossover thinking to be done there about how better to regulate those markets. So moving on to a number of really key problems. We've got Jane Jenkins and Kate Gough, both from Freshfields. Do take it away. I'll leave it. I assume you know which one, who's doing what, where, what, when.
We do, Michael. Thank you. As Michael said, hello, I'm Kate Gough, and I'm counsellor at Freshfields. And my colleague Jane and I are going to address the approach to bid challenge, debarment and contract administration in the Green Paper. It's necessarily going to be a whistle-stop tour, and the reforms are very wide-ranging. So we're going to just focus on a few key highlights in the areas we consider to be of kind of most impact. So first on bid challenge. Remedies are addressed in Chapter 7 of the Green Paper, which sets out the fair and fast challenges to procurement decisions. And the key focuses of the amendments are to address the core criticisms of the current High Court regime, which is that it's too slow, too expensive, and that it does not provide bidders with effective remedies. So against that context, the key elements of the reforms are an introduction of a tailored expedited procedure, a potential tribunal system for low-value claims and claims while the procurement's on foot, a shift of focus to pre-contractual remedies, caps on damages, a removing of the automatic suspension of contract making for contracts let in crisis or extreme urgency, and the removal of a mandated requirement to provide an individual debrief letter at the end of the process. So really our focus is going to be, well, what does this mean for bidders and for contracting authorities? And as I said, I'm just going to take a few examples. So the first area that I think is likely to make a real change is the shift of focus to pre-contractual remedies. I think the general view across the piece is that this is to be really welcomed. I mean, a kind of key criticism of the current regime is that there's far too much focus on damages as an effective remedy. Damages are not the remedy that bidders want. They want the contract, and often they can't really compensate for the loss that they've suffered. And also paying out high damages claims is also arguably not a very good use of public funds. And due to the uncertainty and also the length of the trial process for damages claims, many bidders simply just don't have access to the remedy, and the risks and the costs are just too high. So the Green Paper proposes a range of changes. The preference for pre-contractual remedies and the opportunity to perform the contract is actually going to be stated in the legislation, which seems, entirely sensible. They're going to be streamlined processes to shorten the court timescales for those pre-contractual claims, which is again, really quite an important element of allowing an effective remedy in this space. In another area, a key barrier to pre-contractual remedies in England is the approach that the court has taken when assessing whether or not to lift the automatic suspension of contract making. And it currently applies, the standard English law test for injunctive relief. The result of that is that, it's very difficult for claimants to convince the court to maintain suspensions. So the Green Paper proposes that the test to be applied by the court when considering whether to lift the automatic suspension should be changed and should be a procurement specific test. And I think that is absolutely key to these reforms. It doesn't set out what that test might be. I mean, others have been thinking about it. The Procurement Lawyers Association in the UK has provided a response to the Green Paper, and they suggested that it could include a presumption that the automatic suspension should be maintained. The suspension should only be lifted in exceptional circumstances, and the adequacy of damages should not be a consideration. I mean, they seem to me to be a very good starting point. The Green Paper doesn't, however, address some of the areas that we consider are also significant barriers to pre-contractual remedies. In the United Kingdom, if you're a claimant and you're seeking to maintain the suspension of contract making, you're more often than not, in fact almost always, asked to give something called a cross undertaking in damages, which is where you undertake to the court to pay the loss and the costs of the contracting authority and perhaps the winning bidder that result from the delay in entering into the contract if ultimately you lose. Now, that can be millions and millions of pounds, and it's just often far too much of a risk for the claimant to be able to give that undertaking. So I think to have an effective shift of approach here, it would be helpful to look at whether or not that requirement should be lifted. The next area I wanted to quickly touch on is capping of damages. So the idea, as I've discussed, is that there'll be a shift away from damages to pre-contractual remedies. And the Green Paper then says that if you are in the situation of damages, you should only get 1.5 times your bid costs. And that's the proposal. Now, I think that is a significant concern where in the limited circumstances you might be relegated to a claim in damages, 1.5 times a bid cost is just in almost all cases not going to adequately compensate you for your losses. It also has a real risk of not driving good behaviours by contracting authorities who perhaps could be incentivised to shift towards a damages approach in that context. And finally, very, very briefly on the other reforms, the proposal for a fast track procedure is generally to be welcomed, although I do note Anne's comments in this regard. There are significant questions, however, around the capacity of the UK court to deal quickly with these claims, and also around the effectiveness of a specialist tribunal, which has been proposed. It's unclear how the removing of automatic suspension and extreme urgency will allow for effective protection of bidders. And there are, to my mind, some real transparency concerns around removing debrief letters, even if you look at the wider transparency reforms in the Green Paper. So on that, I'm actually going to hand over to Jane.
Thank you, Kate. Do you think we could move to the next slide, please, Chris? So I've got the challenge of covering 2 topics in -4 minutes, I think we are now. So I will try to be very focused. So I was going to touch on debarment and the changes that are introduced in or proposed in Chapter 4 in relation to exclusion and debarment, and then briefly on contract administration. So the Green Paper proposals regarding reforms of the rules in relation to debarment and exclusion appear in Chapter 4, and they propose a number of changes. The first of these is that fraud is included now as a mandatory ground for exclusion, which addresses a gap in the regulations which previously limited the mandatory exclusion to fraud perpetrated on EU institutions. Secondly, there are 2 new mandatory grounds addressing beneficial ownership. The first is for non-disclosure of beneficial ownership, and the second is to extend the obligation to exclude an economic operator where its beneficial owner is a person convicted of the offences listed in the regulations, alongside those individuals who may have been convicted who have direct control or powers of management in relation to that economic operator. It's an interesting question, not immediately apparent from the Green Paper, whether majority beneficial ownership will be required or merely a beneficial interest in the economic operator. And it's an interesting move, I think, if you look at this in the context of the broader political shift. There's already been reference made by a number of the speakers today to the increased scrutiny in relation to transparency generally. And there is increased concern in respect of transactions under the National Security and Investment Bill, which permits the call-in of such transactions, M&A transactions, for example, and the ability to unwind those transactions if it is considered that the beneficial ownership of assets raises a national security risk. There are then minor amendments to tidy the provisions in relation to mandatory and discretionary exclusions for tax offences. More substantively, the Green Paper contemplates the setting up of a debarment list and the adoption of a database recording past contractor performance, in both instances based on the US model. Borrowing from our friends at Professor Chris Jenkins will no doubt be aware of the paradigm and the model that is being investigated in this context. So as you'll know, the approach currently under the EU regime requires the assessment of grounds for exclusion on a tender by tender basis by reference to self-certification and representations that each tenderer has to make, typically as part of the procurement process. There is currently in the UK no blacklist, i.e. no list of debarred contractors, such as is maintained in the US and by institutions such as the World Bank, which all multilateral banks then have regard to. The advantage of a central debarment list, of course, is consistency of approach, avoiding the need for each contracting authority to assess the question independently. However, the Green Paper poses and acknowledges some challenges. So who's going to manage the debarment list? There'd need to be machinery, of course, to deal with an appeal against inclusion and removal following self-cleaning or remediation measures to demonstrate that the economic operator is once again reliable for the purposes of contracting. And there would be additional challenges noted in the Green Paper, collecting information for non-UK suppliers. And as a further question, would a party wrongfully included on the list, who is as a consequence debarred, mandatorily excluded from tenders, have the opportunity to claim compensation for lost opportunities and reputational damage? So some lessons can be learned from systems that do operate debarment lists, such as the US and again the World Bank, and I would defer entirely to Chris Jenkins on these. Interestingly, the Green Paper references again the US system of monitoring contractor performance and proposes to introduce a similar system to compile an evidence-based database addressing past performance against KPIs or key performance indicators, which are seen very commonly in complex procurement, public contracts for services and the delivery of works in the UK. And the proposal is that all contracting authorities can access, for the purposes of exercising their discretion, whether to exclude suppliers for poor past performance, this database. This develops the existing position in two respects. Most materially as a matter of mechanics, by reference to such a database. We don't have such a database at the moment. Secondly, as an expansion of the grounds for discretionary exclusion, which currently address substantial or persistent breaches, leading to termination, damages, or other comparable sanctions. The Green Paper talks about failure to meet these key performance indicators. Now, to my mind, I'm not convinced that that of itself is much of a development, because I would think that the language of comparable sanctions to damages would include the service charge deductions that you see in the model service contract for failure to meet KPIs. Finally, the reforms make it clear that entry into a deferred prosecution agreement provides a further basis for discretionary exclusion. And no doubt this follows on from the decision in the G4S case, where Mr. Justice William Davies, who approved the deferred prosecution agreement, emphasised that the court's approval of a deferred prosecution agreement should not of itself be determinative of a procurement decision. Whether fraudulent conduct should lead to exclusion, he said, is a political judgment, not one in which the court should play any part. So, in other words, the approval of a DPA, to his mind, should not de facto determine whether or not a company facing fraud charges would be debarred from public procurement, not least because self-cleaning is a relevant factor that may be taken into account. So, turning quickly, mindful of the time, to effective contract management. Now, of course, historically, EU procurement law is not a tool for effective contract management. The rules are all focused on the process leading up to the award of the contract, and those negative controls that are in place during procurement, such as restrictions on material change, are very much negative controls. Interestingly, there is a new module on the King's College diploma, which poses the question whether procurement law secures better contract performance and very much looks at the role that procurement law can play in the context of the continuing life of the contract once it has been awarded. Now, historically, the UK has been willing to go further than the directives and issue detailed guidance and policy. So, for example, most recently, in the wake of the Carillion insolvency and the fallout from the Carillion insolvency, the government has published an outsourcing playbook which gives guidance to contracting authorities, not just confined to the tendering process, but all of the life of the procurement, going beyond the award of the contract into the contract management phase. Similarly, there is a construction playbook which was issued just before Christmas that gives guidance in relation to the criteria for social value. And then there are PPNs, procurement policy notes, which include one that was issued in December on social value, mandating that central government should ensure that 10% of the evaluation criteria are attributable to social values. This is where Michael gets his nice 90% MEAT from, with 10% going for the social value. Now, against this backdrop, the Green Paper proposes further measures to tackle payment delays. Any tier of the supply chain can raise payment delays with the contracting authority. The contracting authority has the right, so they suggest, to investigate payment performance at any tier. Now, it seems to me that this may result in unwelcome interference in circumstances where the prime contractor is exercising legitimate rights of deduction, in turn to manage its own exposure to claims from the contracting authority under its prime contract. So it'll be interesting to see how these points come through in the reforms. And it seems to me that this point should also be read alongside the proposal for payment performance of an economic operator to be treated as an evaluation criteria. And in another part of the Green Paper, it is posited that this is an example of one of the exceptions to the requirement that evaluation criteria must relate to the subject matter of the contract. So further reforms address increased flexibility to amend contracts in times of crisis, in response, no doubt, to the recent pandemic and the experiences of the last year. A new requirement to publish contract amendment notices, which rolls into the transparency points that Ruairi was mentioning. And finally, a capping of profit on extensions, where the incumbent raises a legal challenge. Now, that may be the contracting authority and the government wanting to manage its own exposure in the context of claims for damages and payment out in respect of and in the context of bid challenges that Kate has touched on. It seems to me that if an incumbent provider has legitimately raised a challenge, and in those circumstances, the contract award to the winning bidder is indeed suspended, it follows naturally that a sensible intermediate course is for the incumbent to continue to perform the services pending the outcome of the court's decision. Now, if it is charging the normal contract profit in those circumstances, for my part, I don't see that as being immediately offensive. So perhaps what the Green Paper is aimed at is circumstances where contractors, incumbents, seeing that they're at the end of the line, so to speak, are racking up the profits to exploit their position. So with that, I will hand over back to Michael to introduce the next speaker.
Thank you, Jane. So I think it's Albert who's brought with him the next generation of procurement legal talent, and raises an important question which goes back to the social goals. How are we going to make procurement work for the next generation? Anyway, over to you, Albert.
Well, thank you, Michael, and thank you for having me, despite having to have this duo intervention, and apologies for any punctuation of my points that my assistant makes. I'm a bit surprised about the tone of everybody that preceded me, which I think has been extremely measured. And I will be a bit less measured, maybe just to provoke a little discussion. But I just think the green paper it's not a lost opportunity. It's just an overblown claim after another. Starting with the title, it says it's transformative, and it's not, but it's just an exercise in labeling more than anything else. Most of the changes are very minor changes to the current EU-based rules that basically stem from the fact that the UK decided to just copy-paste them into legislation. And this is a long-lasting policy approach to prevent gold plating of EU law when transposing it. But basically, the problem is that the EU rules are not meant to be applied in isolation. They're meant to be embedded in a system, usually of public or administrative law. And the UK hasn't done that. That's why there are some gaps, and there are some things that don't really work. But most of what the green paper tries to do actually can be done under EU law. Of course, there are some tweaks that cannot be done, and particularly procedurally, so the creation of the new flexible competitive procedure could not be possible, or the creation of these open frameworks. But everything else pretty much can be done under the EU rules. So the first thing is that it's not such an Brexit dividend, defense excluded, as Luke discussed earlier, because almost everything can be done. The second thing is that there is a background of Brexit rhetoric that has pushed for the publication of the green paper that we need to concentrate on as well. And we shouldn't forget Dominic Cummings's great hopes for a red tape bonfire that would come after Brexit. And the green paper doesn't do any of that. If anything, the green paper is going to overcomplicate things by hyperinflating the volume of guidance that contracting authorities have to look at. So yes, maybe the rules in primary and secondary law are going to be trimmer or shorter, but the aggregate volume of documentation that a contracting authority will have to look at is going to be much, much bigger. And maybe for contracting authorities, that could be okay. Maybe they understand all of the distinctions between the different documents, and they can make a trade-off between whatever is going to be in the national strategy with whatever is in the PPN or in the specific guidance, although they will struggle. But for bidders, in particular for SMEs, and also for third sector bidders, which is what Anne and Ruairi have been talking about, that usually have very limited resources to engage with the legal side of their tendering, this is just going to be a massive red tape exercise that is not going to help them put the effort into innovation. So basically, the two main claims in the ministerial forward, Brexit dividend, reduction of red tape, flexibilization, and speeding up procurement in the UK, that's just not going to happen. And I think we need to be very clear about that. So then the question is, if this is not going to be transformative, and this is not going to change the game, what is it that we can achieve? And actually, what can be achieved is very small step increments in different places that, yes, tend to create some more flexibility for the contracting authority, but we don't know how much flexibility is going to be created. Take some of the issues that have been mentioned. So take award of the contract on the basis of the most economically advantageous tender. Now we're going to change it for the most advantageous tender. But the green paper itself says it's going to be the same approach. We're just trying to remove economically from the label so people are not confused by that. Take the issue of damages. Other than the capping, most of the discussion about damages is because there is a misunderstanding in practicing surroundings of what damages you're exposed to if you don't reach the threshold of serious infringement of the procurement rules. And usually, if you don't reach serious infringement, the damages are going to be very limited, if any. And that's the case. The green paper recognizes it, but they say, well, since people don't really know it, we need to change the rules on damages. So there's quite a few of this. We're not going to change anything in substance. We're just going to call it something different, which I think brings back the point that what the green paper has identified is not really a shortcoming in the law, but it has identified two big shortcomings in the UK. One in training and commercial capability, the other one in litigation culture, right? So those are two big driving forces behind the discontent with the rules. The first one is that the contracting authorities, particularly at local level, have been strained. They haven't had time to engage with the new rules of 2014 when transposed in 2015, and that's why the flexibility in the rules has not been exploited. because it's not understood, because there is risk aversion. We keep doing things as we used to do under 2006 rules, which are more or less keeping us safe. The second one is because it's so expensive and so difficult to litigate, and because you will usually only litigate past the point where you can get anything out of it except for damages. We also don't have a good understanding of pre-contractual remedies that we want to enforce. But let me tell you, based on the Spanish experience, the problem with pre-contractual remedies is that your procurement processes tend to last a very long time, because you publish your call for tenders, somebody appeals this thing or the other, 2 months until it's decided, it's changed, re-advertised. And then again, something on selection, and then again, something on evaluation. So by the time that you can award, maybe you've spent 2 years in short pre-award litigations, and that's a different model, but it's not necessarily better than what we have. And that's not been thought about. The other thing that hasn't been thought about is, what is the cost of the flexibility we want to create? So take the competitive flexible procedure that, to me, it's just the anti-regulation approach to procurement. Every contracting authority can set its own rules, no boundaries except compliance with the general principles that we have heard about, as long as this is advertised and that whatever you say in your contract notice, call for tenders, that's what you do, right? That means that every contracting authority with an imagination can come up with multiple small tweaks on any procedure that they had used before. So every time that somebody wants to tender, they have to engage a legal advisor, whether in-house or outsourcing it, to tell them, how is this going to play out exactly? And what minor deviations you have to be mindful of. So that is, of course, a very big increase in the complexity of the system and in the transaction cost of the system. So again, SMEs, third sector entities, much less likely to be able to absorb this. So all of these alternative approaches to delivery of not only social services, but almost any other services, wanting to use procurement to dynamize the local economy, probably not going to happen. The last thing I would like to say is that there's a very fundamental incompatibility of incentives. And this is something that Anne has mentioned in her presentation, but I would like to stress it a bit more. When you have a very commercially oriented procurement system, when you want people to innovate and to take risks, you have to have a system that tells these people, you're going to be rewarded when you get things right. You will not be punished when you get things wrong. You will have to learn. So the only thing we want when you get something wrong is for you to learn and for everybody to learn from your mistakes. But otherwise, people will not take risks. When you're creating very flexible rules that are principles-based or exception-based, when you are opening the system to challenge, and when you're going to have a creation of registers of complaints, registers of litigation, and you're going to have a unit looking at that, I want to see who is the public buyer that's going to go and say, oh, I have this great idea. Nobody has tested it before. Let me have a case in the Supreme Court with my name on it because I really fancy that, right? So it's going to create massive chilling effects. And the whole purpose of the transformation that we expect is just to free up the public buyers to be imaginative, innovative, forget about procedure, they concentrate on substance. They're going to freak out about procedure. They're going to lawyer up so much every time they want to do something new that they will just not do it, because I don't see any legal opinion coming out with no caveat saying there is this risk or that, or this is unexplored. We're not sure how the Supreme Court is going to decide that. So what I would say is that the Green Paper just got it wrong. What they did is they assessed what the situation in the UK. They said, okay, we have underinvested in our procurement task force for a long time. We have under-trained them, and we have a problem with commercial capability. Well, fix it first. See how far you can go with the existing rules so that your training is going to be easier and more effective. At least we know the rules and we have something to go about in terms of their interpretation and their practice. And once you reach the limit of the existing system with a better trained, upskilled procurement force, then think about how you want to change it. Because otherwise, what are we going to do 5 years down the line? We want to assess the effectiveness of the legal reform. And it hasn't worked because it won't. Are we going to blame the new rules? Or are we going to blame the training program that was never properly funded by Treasury? Because let's face it, we're not looking at very buoyant public expenditure years ahead of us. Or what are we going to do? So we're creating multiple possible claims on why things didn't work, which is not a good thing when we're looking at legal reform. So my claim would be that the Green Paper should just concentrate on what's useful. What I think are useful are just some aspects of Chapter 6 on transparency, but we should remind ourselves that they want to keep the Freedom of Information Act as it is. And that is the main constraint on transparency in procurement, not the OECDS, which could help, but it's not the whole thing. and some things on complaints and on trying to create a more continuous growth, continuous understanding culture. But other than those two things, everything else are complex tweaks on rules that are going to create exceptions that are going to be litigated and that nobody really will take advantage of. So to me, it's not that it doesn't do what it says on the tin, it's just that the green paper is basically now, at best, a catch-up with a bad transposition of EU law for maybe 2 decades, but it's not transformative. If we want to be really transformative, then start over. Start with the training, start with the electronic procurement seriously, and then think about the rules, because the rules are much less constraining than we heard. And on that, I strongly disagree with Chris Vajda, but we can discuss this a bit more in the Q&A. And thank you for putting up with the ruffling and the shouting and my own blabbering. Back to you, Michael.
Thank you very much, Albert. It's important to have comment on everything. I mean, but I certainly underline what you say about the obligation, the mandatory nature of the guidance. I mean, the idea that you can devolve something down to guidance and avoid legal obligations is, well, just nonsensical as a matter of English law, and whether you're in public law or private law. Chris.
Thanks very much, Michael. I will try to wrap up quickly so we can get to the Q&A. So my perspective is an American perspective, and to try to offer some insights on how it's my share lessons learned with the UK as you move forward. My comments on the green paper are posted on Public Procurement International. As a starting point, I note that the comments that were submitted to the green paper are not publicly available. That's, from a US perspective, major no-no. That we regularly post our comments on proposed regulations on regulation.gov. What a government does when it hides the comments is it's trying to foreclose coalitions among the commenters. Everyone understands that, so I think it's a mistake for a government to do that, to hide the comments. They should be public. When you're dealing with the U.S. as a negotiating partner, opposite, you should understand that the U.S. tolerance for a stupid sloppiness is no longer there. With over 4 years of the Trump administration, we lost over 200,000 people in the pandemic due to sloppiness. We had many people died otherwise. It's regular violence against Asian Americans. You can go across the board. And the withdrawal of the essential medicines proposal is the most recent example of that. So when you're dealing with the Americans as negotiating partners, assume that they're coming fully prepared and they're fully professional. There's no more sloppiness in the negotiations. That said, the United States shares the principles of the United Kingdom, shares the principles of open trade, democracy, all the basic principles are shared. The United States is just taking tactically on a day-to-day basis a different approach. One important aspect of the green paper is it opens up all levels of the UK market. What we would call the central government, what would be equivalent to our state governments, our local governments, they're all open. The United States has not opened up all levels of its governments. The United States has relied for over 20 years on this very vague argument that there's a constitutional reasons that the state and the state governments can't be open. There is, in fact, though, no legal analysis, as far as I know, and I've asked, there's no legal analysis supporting that constitutional argument. When you're dealing with professional lawyers in the US government, if there's no memo in the file, the argument doesn't exist, okay? So this whole argument that there's a constitutional bar to accessing the state governments is legal nonsense, and it shouldn't be accepted in the negotiations. There are many ways that the US government can leverage the states to open up the subcentral governments to free trade as well. On debarment, we're noting with interest that the Cabinet Office is going to take on the role of supervising debarment. The US government tries to balance political or reputational issues and performance issues. If the debarment function is lodged in the Cabinet Office in the UK government, the Americans will be very concerned that in fact, political decisions are being made, not performance decisions. The US system has evolved since the mid-20th century so that the debarment function can balance both issues, reputational and performance issues. And my recommendation would be that the UK system be set up so both reputational and performance issues can be dealt with. In terms of bid challenges, there is an international norm of having agencies themselves be able to handle challenges, that there be an independent agency and there be courts. This has worked well internationally, and that's an international model that can be recommended to the UK government. Corporate compliance issues, what's referred to as self-cleaning. or to use the German word, Selbstreinigung. Selbstreinigung, self-cleaning. Self-cleaning means you clean yourself when you're dirty, okay? That's not the appropriate approach from the US perspective. This is exactly where the US was in the late 1990s, early 2000s. Should contractors follow a corporate norm of having compliance systems in place all the time, or should they only take compliance measures after something goes wrong, okay? The Americans, in 2008, we pivoted, and now we require corporations to have compliance systems in place all the time, not just when something goes wrong. And in fact, that's exactly the approach called for under the UK Bribery Act. The UK is already there under the Bribery Act. Call for contractors to have compliance systems in place all the time. Competitive negotiations. 60% of the US federal procurements are done using competitive negotiations. 2% are done using open tendering, okay? Competitive negotiations are critical for successful acquisition of complex weapon systems and complex IT systems. The UK is probably the most important ally of the United States. We strongly encourage you to take a hard look at competitive negotiations, refine, make it more sophisticated. Don't consider it as something odd. It is the mainstay in our procurement system. The last is to set up a means of regular regulatory cooperation. No one in the US government, this is important, no one in the US government is accountable for open discussions with our allies, with our friends about regulatory cooperation. In fact, it's the flip. If a senior person in the procurement community says, you know, the Brits have this idea, maybe we should follow this too, they're derided because there's xenophobia built into our system. Somebody in the US government has to be accountable for opening the bridges. It shouldn't be limited to these types of academic discussions, but it is. And that's something to push for from the UK side. Make somebody accountable for communication. Thanks a lot, Michael. Back to you.
Great. We'll try and stick on for a couple more minutes. We had a number of questions, and I'm not sure I've caught them all. Maybe I can pick up one, which was a simple question from the beginning, but simple but important question. Just read it out. Isn't it a good thing that what's in the public good should be subject to scrutiny, including as part of procurement challenges? And we might have some differing views of that on the panel. Maybe Albert, would you like to have a crack at that one? Are you up for that one?
Sure.
Should we be challenging what is or is not in the public good in a is that really a justiciable question?
I don't think it is. So I think the issue with procurement is that it should come after that decision has been made, right? So that's a political question. What is in the public interest? What are we spending taxpayers' money on? And if people don't like it, then they're going to vote us out. But we shouldn't be litigating that. I don't see how the court's in a better position to assess what's in the public interest or what is not. A different story is when you have made that decision, how you go about it. Then it's of course in the public interest for it to go about it transparently, in a non-corrupt way, in a competitive and open way, transparency where applicable. But I just think that determining what is in the public interest, in other words, how is money spent, is not what the courts are for.
And did you want to jump in on that?
Yeah, I think I'm inclined to agree with what Albert just said. We have other mechanisms for working out what's in the public good, and they're largely political. And putting that as something that might be, negotiated between officials and contractors, and then subject to judicial review, just doesn't feel like the right location for those kinds of questions to be being addressed.
I mean, I suppose my comment on this is it's a problem of making public good a legally enforceable principle rather than a goal. If you make it a legally enforceable principle, leaving aside the question which Christopher asked at the beginning, what does it mean? If you make it a legally enforceable principle, then at some point someone is going to court and say, I don't think you've designed this procurement in a way that matches up to the public good. So, and perhaps it just, maybe but it is a difficult one. If it's a political question, maybe it shouldn't be there at all. So picking up another question, should the oversight unit or any part of this oversight be within the Cabinet Office? This is the fox in charge of the hen house question, isn't it? Should the Cabinet Office be left in charge of procurement control and be running the independent monitoring? Or should we be looking to have an independent monitoring unit? Any thoughts on that from anyone? Anyone want to dive in on that one? Christopher, do you want to have you got any thoughts on that one?
Yeah. Can you hear me?
Yes, we can hear you very loud and clear.
I think, particularly in the light of the remarks of Chris Jenkins, I am very much in favour of having an independent monitoring authority away from the Cabinet Office. We have to bear in mind that 20, 30 years ago, we had no independent regulators. We now have competition authorities, data controllers, regulators in the Ofcom and various other fields, and they all have to be independent. And I think that's very, very important, particularly given that the government is a very large user of public procurement. So I think that all cries out for an independent monitoring authority.
I'm just trying to put a note as well at the same time. Does anyone want to pick up on that, the independent monitoring authority point? Oh, yes, Albert.
So I think one of the reasons why this unit has to be created is that the European Commission is no longer there. So in part, this is because of repatriation of some of the powers under the directives that have been taken by Cabinet Office. I think that the PPE experience, to call it that, shows that it's a bad idea to have government looking at what government does in terms of procurement. I very much would prefer an independent authority. And that doesn't mean it has to be the same one that knows of appeals on specific procurement processes. I think the Green Paper gets that right. But I think the location is very problematic because politicization of that is what you really want to avoid. So arm's length, if it cannot be in Brussels, then at least make it be Manchester or something.
Yeah. There was a question about the NI protocol, which maybe, Ruairi, did you want to comment?
Yeah, on that idea of oversight, who's doing the oversight really matters, and the skills of the oversight body and the capacity. If it's a commercial focus and it's all commercial expertise, and this is a procurement system that is also doing a lot of is trying to achieve things like social innovation, then the makeup of that body, I think, and the capacity of that body to deal with different types of subject matter, I think becomes really important.
Thank you. Shall I pick up the NI protocol question, which I think John Gibson raised very briefly? Others will have different views on this because this is a bit controversial and still a bit murky. But my reading of it is that the NI protocol doesn't directly deal with public procurement, but by operation of the NI protocol and the trade and cooperation agreement together, you have a number of ways in which EU public procurement law may still, as it were, leak into Northern Ireland, either through the provisions of Title VI dealing with under the below threshold procurements, or through state aid, where of course the link between state aid law and public procurement law will often drag us back into, drag Northern Ireland procurement back in under the EU regime south of the border. Having said that, what Brexit has done is it cleaved in two all of those cross-border procurement arrangements, because the contracting authority in the north is no longer a contracting authority in the south. And so all of those provisions on joint procurement and cross-border procurement under Article 39, if I got that right, can't remember, simply don't work anymore, because they all assume that the cross-border purchasing is being done by contracting authorities in another member state, and that just ain't true anymore. And so that which has a huge impact on a number of important all-island procurement programs, which is sad, but hey ho. Not the saddest part of the NI situation. Thank you, Albert. Your assistant needs tending. Well, your assistant needs to be prepared for the next phase of procurement law reform. There are other questions, I'm sure, but I've missed, Chris. Have you kept? Are there other questions we should? Is there a last question or two before we should let everyone go?
There were questions regarding digitalization, but we had a chance to address those in the chat. So
some of those.
Thank you very much, Michael.
I think unless anyone spotted a question in the chat which they feel they want to pick up on now, I think we should take the opportunity of calling that a day. The record, as Chris says, the recording will be up. I think the conversation could have gone on for hours. Thank you all for turning up. It's been a splendid turnout. Thank you all the participants for a splendid occasion. to me, I find it really, it's very exciting to see all of the work that's being done in this field in such an important area of law. Can we all can all the participants thank and all the attendees thank everyone in the traditional manner. If you're able to switch on your phone, I don't know if we've done it so that we can switch on cameras, but anyway, thanks in the usual way, and I will do my usual waving in the air. Thank you very much indeed. If we didn't answer your question, apologies.
It's a privilege. Thank you all.
Thank
Bye-bye.
you.
Thank you, everyone.
Thank you, Michael and Chris, for organising.
Have a wonderful day.
Bye.
Right.
Well done.